Court calls the case of the people versus Caitlin Quinn.
She stood in court and admitted everything, the drugs, the mistakes, the guilt. Everyone expected routine sentencing, but the judge looked deeper, and what happened next changed the entire room.
You were right. I was wrong. Morning, Your Honor. For the record, Brian Stacy, P33014. State your name.
Caitlin Quinn.
All right, I have before me a plea form that indicates that she's going to be pleading guilty to the charge of use of methamphetamine.
This wasn't supposed to be dramatic. A guilty plea, a routine drug case, paperwork, and sentencing. But when Caitlin Quinn stood before the judge and admitted everything, the courtroom shifted. Because sometimes the law isn't just about punishment, it's about deciding whether accountability ends a story or starts a different one.
Amphetamine, the 1 year offense. Upon a successful plea to that charge, count one would be dismissed. That's, of course, full understanding of the.
That's accurate, Judge. I have had an opportunity to explain to my client her rights in detail. I believe she understands them, and at this time, knowingly, voluntarily waive them and lay a factual basis to the added count.
May I have her sworn? Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty. Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep. Yes, Your
Understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of September 4th, 2025, Washtenaw and Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11th, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, well, go ahead, counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail. She's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently, she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention. And And she was hoping to, her daughter's 15 years old, she's homeschooled, and her grandmother is 86 years old, and she's been diagnosed with Alzheimer's, and she was hoping to move in with her, and her daughter would be with her and to help take care of her grandmother. Her mother, I believe, is.
Are you going to be able to test clean if I let you out?
Yes, sir. I've learned my lesson, Your Honor.
I'll reinstate her previous bond with the testing, and so she'll be released on PR.
Thank you very much for your consideration today, Judge. You have a good day.
You do the same.
Thank you.
Court does call the case, People versus Jennifer Burnside.
For people.
Morning, Your Honor. Jason Hagelthorne on behalf of defendant Jennifer Bernstein, who's present
Good
standing.
morning, Your Honor.
Good morning, your name?
Jennifer Burnside.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year. On her successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to enroll and participate in the 14A sobriety court. There is also a sentence agreement. Well, it just says the 14A, it says A3, but it's 14A sobriety court. Defendant has been accepted as of January 29, 2026. And there is a sentencing judge waiver checked off. That is the court's full understanding of the agreement.
Yes, Your Honor.
Yes.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Say your name, please.
Jennifer Burnside.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle forfeited or could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
I do, Your Honor.
You wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your
You
Honor.
understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily
I am, Your Honor.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 10th, 2025, at the location of I-94 near Freer Road in Sylvan Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed, I guess, alcohol and cocaine
I did, Your Honor.
and THC also.
Yes,
Is that correct?
Yes.
All right. Were you stopped by the police?
Yes, I was.
All right. Why'd they stop you?
My turn signal was burned out
All right.
when I went to go get on the highway.
All right. Were you arrested?
I was, Your Honor.
Were you taken to the hospital for a blood draw?
I was, Your Honor.
And what were the results of that blood draw regarding alcohol?
0.97, 0.097.
0.097. All right. Did it also show the presence of cocaine or its derivatives as well as THC and or its derivatives?
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And ma'am, had you previously been convicted of operating while intoxicated on or about June 25th, 2023 in the 53rd District Court and operating while impaired on or about February 25th, 2006 in Farmington Hills District Court?
Yes, Your Honor.
All right. Ma'am, if I accept your plea, I do have to advise you if you commit misconduct between the time I accept your plea and the time of sentencing in this matter, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
All right. And have I complied with the court?
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 3, excuse me. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation. Sentencing in this matter will be March 9th, 2026, 9 a.m. before Judge Freshour. Bond will continue.
Your Honor, I did have one request renewed from the last time we were here. Ms. Burnside has a pretty severe cut. I know the probation, the testing facility, Keith over there had checked it. He has recommended her, and I believe he's going to accompany her to medical for that. They did switch the leg, but based on that, would the court be willing to transfer to the sober link and a release of that tether?
Response to people.
Judge, we'd ask, being a photo manager in the next going to this Friday court, we'd ask that the tether remain. If the court is willing, Mr. Heaton did give us a possible sentencing date of February 12th.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. Esteban.
Thank you, Your Honor. Ms. Clements is in custody based on a prior failure to appear at a probable cause conference on September 11th. It's my understanding that after this alleged incident took place, she was hospitalized at St. Joe's, and then St. Joe's transferred her to Stonecrest, and she was in Stonecrest from September 9th to September 26th. She was suffering from long-term memory loss. She had a concussion, and she was having some other mental health issues. I did try reaching out to both of the facilities. I sent releases of information to both. I haven't gotten any records back at this time. But once she was released from Stonecrest, she was working with leaf harm reduction. She can either stay with a friend in Ann Arbor, Your Honor, or she can stay at the Delonis. She does provide me this address. And
how'd she come back into custody?
What were you brought back?
Officer just took me off the bus, no reason. I wasn't in no trouble.
So, Your Honor, I believe in that.
He just came on the bus and grabbed you?
Asked Officer Lawrence, he did.
Because he knew you had a warrant.
He knew I had a warrant, but I didn't know I had a warrant at the time.
So, Your Honor, with that, I would say that there was no new charges when she was brought into custody. It was just officer recognition and being aware that she had the warrant, so they brought her in on the warrant. Like I said, Your Honor, I'm still waiting back on any of those records, but at this
So I
time,
don't have any medical to verify what you're saying, and she was gone for about 4 months.
yes, Your Honor, but I'm hoping those records will be here very soon. Like I said, I sent releases of information to both
But
St.
those
Joe's.
records aren't going to explain the 4 months. No answer needed. I don't need a response. Motion for bond reduction denied. Bond voted. Thank you. Court calls case People versus Abdul Latif. You know what? You keep talking. You want me to op it? Oh, give me the file. You want to be smart? You can just let her know her bond's revoked. Mark the file. Court calls case People versus Abdul Latif. Good morning, sir.
From Flood Center, Daffy Lebo, on behalf of Mr. Latif. Mr. Latif, can you tell the court your name, please?
Latif.
You need to take your hand out of your pocket. Anything you want to say to me? No, I'm kidding.
Your Honor. Your Honor, we're going to be requesting an adjournment with no complications in order to just finish verifying some discovery.
Okay. I will adjourn this then February 12th, 2026, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Thank you.
There you go.
Thank you, sir. Court calls case People versus Joseph Griffin.
This wasn't just a guilty plea. It was a moment where addiction met accountability. The judge had a choice, punishment, or possibility, and the decision shocked everyone listening.
You got that file, Mark.
Good morning, Your Honor. Veronica Glenn requesting permission to practice under pursuant to Michigan Court Rule 8.120, practicing under assistant.
How many
public
times have you
defender.
said this? Come on, you're with Canon, right? Is this the stage fright that's just going through? No? Start again.
Okay. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120, practicing under Assistant Public Defender Stephanie Cannon.
See, wasn't that hard? He's a
not.
product. Yes, you got permission to practice is granted.
Thank you. Your Honor, we're requesting adjournment in this matter.
All right, purpose of the adjournment?
We need additional discovery, or we need a discovery.
You need it.
Yes.
Conference without objections adjourned to February 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the People versus Diamond Buyers. All three cases.
Morning, Your Honor. Raymond Cook for the People.
Morning, Your Honor. Edward Jukes on behalf of Diamond Buyers.
Diamond Buyers.
Thank you.
Your Honor, there's some negotiation going on. There is another case that just is authorized, and then there's another one coming down the pipeline. That's what I was told yesterday. I'm looking for an adjournment.
So, Your Honor, there was another case of financial transaction device authorized on the 26th by our office. There's also one pending in the warrant queue. These all stem from roughly the same time period.
So I've got one. Do we have a date set on the one that was on the 26th?
I don't believe so. Let me check my court to confirm that, but I didn't see one when I looked earlier. No, I'm not seeing if there's any dates set on. I don't know if it's either the sworn to.
Yeah. Okay. All right. That's fine. So basically, I could potentially I'm expecting one, but then there may be another one. So there may be two.
There's definitely 4 total, maybe a 5th one.
Got it. Probable cause conference, what I'll do is I'll adjourn this out to February 26th, given all of that. I'll need green sheets.
Okay, thank you.
2026, 9 a.m. Her crime will continue. And I guess so that those are tracking, if the other one does get sworn out, she's arraigned on that one, however that may occur. I don't mind setting them out to stipulate to adjourn it to this date. So I'm putting it out far enough. Hopefully we can get all that on one date. Okay.
Thank you.
On continue. Thank you. Court calls the case of People versus Spencer Norton, 2 cases.
How is that on behalf of the people?
Good morning, Your Honor. Edward Jukes on behalf of Spencer Norton at 1768.
And the Assistant Public Defender, Shanazia Fair, Your Honor, on behalf of Mr. Martin in the other matter.
Good morning, Miss Ackerman.
Good morning.
So you're sitting there and didn't hear a word from you.
She's been talking to me all morning.
She's been in your ear. Okay, I got you. Okay. What are we doing? In your name, sir?
Spencer Norton.
Thank you.
Looking to set ours for an exam, and I think the other one's going to come along with it.
That is correct, Your Honor.
Both set for exam?
Yes.
All right. Discovery is complete on both of these?
To my knowledge.
To my knowledge, Your Honor.
And do people have their witnesses available the 10th?
We'll do our best, Your Honor.
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Garwood. You may.
This wasn't just a guilty plea. It was addiction meeting accountability, honesty meeting consequence. The judge had a choice, punishment or possibility, and the courtroom felt the weight of that decision. Because in moments like this, justice isn't loud, it's deliberate.